Hello and welcome to Trusts and Estates Weekly. I'm your host, Kevin Bemmel, and we are here every Monday at 10 a.m. Pacific time to talk about all things related to estate planning and the administration of probates and trusts, both from your own financial needs and from that of professionals like myself and my guest, Bill Gross, who help people with these various facets of their financial lives. And because I have a guest today, I want to jump right into it. Bill has been a guest on one of my shows before, but I think this is the first time you've been on Trusts and Estates Weekly, a title that I stole from your show, Probate Weekly, as you know.
Well, it's a brand extension, right? Probate Weekly is my focus, and Trust is your focus. So Trust and Estates Weekly. So I think of it as brand extension.
Well, I did ask you beforehand, so I got your blessing. So.
That's great.
But you know what they say, what is it? Stealing is the biggest form of flattery or something like that. So.
Well, and again, I mean, to be honest, all kidding aside, I don't see this thing as much as I do think that it's trying to extend the brand and the idea. A couple of things. One is professionals that we need to work on our craft every week. I think it's one thing to market, and you can argue do it daily or every other day. But I think working on your craft is something we should be doing daily and at least have a weekly set time to do that. And so that was my thinking when I set Probate Weekly. And I think it, in your case as well, it works well that I watch your episodes and your speakers. And once a week, I get a little more insight into Trust and Estates, which is good.
Yeah, absolutely. It's interesting. I didn't think of it in that context, but it really doing the show has really been an impetus for me to dig ever more deeply into these various issues. And that, of course, is what brings us together today. So for those of you who haven't seen the social media posts promoting the show, Bill Gross is one of the top probate real estate agents really in the country, certainly here in the state of California. Hopefully it won't embarrass him when I say that Bill's knowledge of probate is so deep and so broad. It goes far beyond just those issues that deal with real estate. We're working on a project together, and Bill has oftentimes been able to bring information to the table that was useful not just to me as the administrator, but also to the lawyer who's working on the case, and also for the heirs. So his experience is absolutely extensive, verging on encyclopedic.
Thank you.
You're welcome. And to, for those of you who are at all involved in real estate or investing, hopefully you've been following this issue. There was a major lawsuit against the National Association of Realtors. And as a result of that, the laws around real estate agency nationwide have changed. And so I invited Bill on the show to talk about that, so that I think they officially changed. What is it, like the 15th or 17th of last month or something like that? Was the official?
Yeah, 17th of August.
Yeah, so it's been a couple of weeks, or maybe about 3 weeks. I think we're at the point where there's some clarity as to how the changes are going to work. Obviously, it's going to play out, but I think it's something we all need to be aware of, both on the professional side and for our own our own investments and such. So Bill, start out if you would, and give us the background. How did this come about? This lawsuit, and what was the intention there? And I don't recall now if the lawsuit was settled or if there was a holding against the NAR. But if you'd give us that background.
Yeah, I think that, I don't really want to get into a political discussion, but I do think sometimes you have to watch the tides and understand the bigger picture and how things fit in. And this is a fight that's gone on for 10 years. I think I would say it's, should we have more regulation or less in the real estate industry? And as politics ebb and flow, we have either more regulation or less regulation, depending on who's in charge. And so this lawsuit was filed. It's really, to me, of all the fake lawsuits we've heard about in our careers and lives, this was one of the worst, in that the plaintiffs claimed to be misled, yet they're very sophisticated. The husband had sold a good-sized business and retired. His wife was an executive at the company. And after closing, they discovered that they didn't know that they had, as traditionally we've done for years, for 100 years, where the two agencies get together and agree and split the commission. Some of it goes to the buyer's side, some of it to the selling side. It had been their listing contract, it had been their estimated closing sheet, but somehow they pretended they didn't see it. They hired an attorney, and one attorney, one judge, one jury in one court case upsets the entire industry. And I don't want to belittle it in that it is having a tidal wave effect of change. Every real estate company is vulnerable, partially because the real estate companies are suffering separately from a 30% drop in volume. So you have companies that are very vulnerable financially, can't really afford to fight. And they were, facing multi-billion-dollar judgments, and they settled for over $400 million penalties. And then now it's interesting that this plaintiff has taken that money and has his own tech startup, which I think is the end game, which is kind of to create a Facebook or Google equivalent of real estate agents, or Uber equivalent to eliminate real estate agents. And I think that, so this is a process that's continuing, it's changing, it changes state by state, agency to agency. It's very confusing. There was a professor of law from Buffalo who analyzed and said as of now that she thinks the contracts are not understandable by the majority of buyers or sellers. I think she's right. They're very confusing. I'll give you a couple tidbit examples. One is, in the past, many of people who've bought or sold homes went to an open house. You'd walk in the door and there'd be balloons or signs or something, and you'd feel welcome. Now, when you walk in, you can't go in without signing some sort of a piece of paper. Now, you can call it a contract or a touring agreement or call it what you want, but it has legal ramifications. It is a contract by law. So you can't even tour a house now without really signing an agreement to somebody to pay somebody something. And maybe paying nobody nothing, but you have to sign an agreement that says that and not good fooled. Another example is this plaintiff who won this case is starting a new company. And what he wants to do is eliminate real estate agents by charging customers to see properties. I think it's $50 per view. To write offers like $199. We've done that for free for years for customers as part of a service to get them into the deal. And so I think that customers are faced now with a whole bunch of choices early in the process. Who's your agent? How much are you going to pay them? Things they never thought about before. And signing contracts are very confusing. And so I think it's more important than ever to talk to trusted advisors, ask questions. And I also would say these targets are moving. We issue documents for the California Association of Realtors. We had to reissue them all 2 weeks later. They're still being updated as we speak. It's a very confusing time. And I don't mean to be negative about it. I think that it's a competitive industry. And if you can learn your way through this or find good advisors, you can excel and beat the competition.
So, historically, and maybe hopefully you can explain this, but historically, real estate was regulated state by state. So
Right.
how is it that one lawsuit in one state, I think it was a Midwestern city, if I'm not
Right.
mistaken, how can one lawsuit have a national impact like that when even if how could it be filed under federal law if it was, and how can federal law on real estate, which really doesn't exist except for in things like RESPA, how can that suddenly preempt the laws of 50 states and presumably Washington D.C. and Puerto Rico, et cetera?
Right. Well, I think this is where the real fraud comes into play, because they couldn't just say the realtor they hired deceived them or the agency. Their claim is that every franchise in the country conspires together with all the MLSs in a way that deceives sellers into paying commissions for buyers. On its face, that's a ridiculous claim, but that's the claim they made. And again, you only have to convince one jury and have one judge willing to play along with that. And as we've seen, I think in a lot of issues that, the judiciary has become very political. But the other part of that, I would say the hammer that goes with this has been the Department of Justice. So, again, without getting into politics, but just to tell you who the players are, Department of Justice under the Obama administration wanted federal regulation of this topic and worked with this lawsuit as a hammer to try to force it. When Obama was out of office and when Trump came in office in 2017, Department of Justice dropped that case because Donald Trump was a real estate developer. He also was an ally of the National Association of Realtors. He spoke at their convention every year. And so this has become, it's kind of like, well, if you like them, you must be the bad guy. And so I feel like the Democrats want to kill the Republican support and vice versa. And realtors are kind of caught in this crossfire. But for the last 4 years, the Biden administration, Department of Justice, picked up this case again. And as a hammer has been beating on the settlement to force and to threaten and to use subpoena power against these agencies. And so the combination of Department of Justice and this lawsuit, and the lawsuit alleges national conspiracies. It is ridiculous. The whole concept, when you think about it, I don't cooperate with. It turns. I have friends at my company, EXP. I also have friends at Keller Williams who sell my listings. Well, I'm as cooperative with them as I am the ones in my own company because they're selling my listing. I have to work with them to service my customer. But this has been an area that I think power hungry regulators want more power, and this has been a huge market they haven't had their hands on, and they've been working on for 10 years. And I believe this is the result of about a 10-year effort, both with the attorneys, a class action attorney, and Department of Justice.
So, okay, so that gives us the background of this, and the result was the NAR entered into a settlement then that I guess is binding on all agents, or just all members of the National Association of Realtors, or how does that work?
Well, actually, there's multiple parties who've settled. National Association of Realtors, along with several of the national franchise companies. But some of the other large national franchise companies have not yet settled. They're fighting it. And there's regional companies and there's local brokerages. Now, local and regional brokerages have the opportunity to sign into the NAR settlement to get protection through the NAR. The way the settlement was written with NAR was to offer brokerages the opportunity to use their service as an umbrella. So that's kind of ongoing. And then, of course, the judge has to approve the settlement. Initially, what happened was at one point there was a settlement, and then it got declined to go back to extract more blood. And so you have these companies. And the other part to think about is you might think of a real estate agent at a Century 21, but the reality is Century 21 has an international franchise company. And then there probably is a local regional company. And then there's a local real estate agent who's an independent contractor. And so just because the international agrees to a settlement doesn't mean the regional franchisor abides by those terms or is liable to those terms, or the individual practitioner. So it's very complicated and I think very difficult to regulate. And I think this also, the other part about all this, it shows how bad regulating by lawfare is, because if you really want to improve things, then pass a law that contemplates a system and puts it into place. I think this is like where the debate over abortion breaks down on both sides, that there's no good answer when the judge makes decisions, kind of like Solomon and the baby. Nobody's happy when the judge decides to cut the baby in half. You have to really kind of sit down and say, well, what's a solution that the majority of people can agree to and work it out politically? And here's a case, I think, crying for some sort of state or national regulation, but just right now it's just piecemealed between, again, various national firms, regional firms, local firms, state agencies. It's very confusing. As a practitioner today, I have a choice between now my company forms and California Association of Forms. That was not the case a while ago. But think about it. When I submit an offer now, the listing agent is another company. If I use my company forms, are they going to review them? Our attorney spent tens of thousands of dollars forming them. Are they going to hire an attorney to review the forms? Again, at the end of the day, the one person who's not being helped through all this is the customer. It's very confusing.
So let's go back to that example you gave a few minutes ago about, someone wants to walk into an open house. I know people who, on a weekend, they just like to go look at houses. Yeah. They're not necessarily even in the market, right? They just like to look, right? And it sounds like, depending on what company is handling that open house, or what agent within that company, what state they're in, they could be faced with a completely different scenario. So focusing on the customer, because as professionals, that's what our duty is. what do we tell the people that we're working with in terms of how to navigate that?
I think the key now is every customer situation is different and unique based on location, based on what they're trying to accomplish. I'll give you an example. I have customers who are very sophisticated investors. They really don't want to sign a lot of unnecessary paperwork. And so in their case, I guess you have two options when you go to an open house. You can sign the form they have there saying nobody's representing me, but I want to look at it. Or you have a form from your agent saying, "Hey, my agent's not here, but it's Bill Gross or Kevin Bemmel, and they're representing me, and they've brought this property to my attention. And since this is an open house, I'd like to look at it." And so I have investors where I've agreed just to to get a contract to them, and I say to them, "Look, we don't have to. I'm willing to negotiate this contract. If you find the property, I'm not going to charge you the same commission as if I do." But they have trust with me. And so we know that that's negotiable and cancelable. I think the hard part is for a buyer who doesn't have a relationship to start with. How do you start a relationship and trust somebody on the commission and trust that they're going to be fair? Well, you earn that trust. You don't get it right away. But I would say, so what do we do? I think the answer to your question is that we tell customers, hey, it sounds good just to pop in a house, but you might end up signing something that prevents you from getting that house or overcharges you by 2.5 or 3%. So before you start looking, let's get with a professional. Let's put a game plan together that's going to work for you. And that might mean getting an agreement signed at a low commission rate or no commission rate or a cancelable agreement or something. But at least that way you know what your options are and don't just walk in. Because the form, like Zillow famously is advertising, oh, we have this touring agreement. It doesn't bind you anything. You don't have to use us. That's true as long as you don't check the box in the third paragraph. But if you check that box, you're paying them 2.5% of your purchase price on any house you buy. Well, that's to me deceptive, but certainly it's potentially misleading. And so to answer your question, I would say more than ever now, take it seriously. This is a big purchase, a big investment. You have a chance to jump the line while the other people are confused. Let's get with a professional and get a game plan that works for you put together.
And so describe now, I mean, when I was most active in real estate, it was what you had described earlier, where, a seller would agree to, let's say, 5% commission. And the listing agent, generally speaking, would offer half of that to what we called a cooperating agent, which was the buyer's agent. And I remember going through a process early in my career where at first there was a discussion about, well, wait a minute, if the seller is paying the buyer's agent, to whom does that buyer's agent owe his fiduciary duty? And eventually, at least here in California, it was settled that even though he was being compensated by the seller, his fiduciary obligation was to the buyer, and that was clarified. And then there was a form created, and it seemed to me to be pretty straightforward, very clear and easy for the client to understand what was going on. You were either the seller's agent or you were the buyer's agent, but in any event, you typically split the commission, and that was all. That was part of the sales agreement. Now it sounds like it's really a confusing situation. So how do commissions work nowadays? How are agents working this out? And especially for first-time buyers who typically are, they're short on cash. And so if they now have to come out of pocket for a commission of even, 1 or 2%, that may be, more than they can afford. So what is the industry doing about, those issues?
Well, that's where I think that an agent, I've been to numerous seminars on this topic to listen to other experts. I've reviewed multiple versions of various contracts. I've talked to colleagues. As you know, I have an active business where I have offers come in. I look and see how other companies are doing it and ask questions. I've talked to brokers at competing companies to learn. And so the way it falls out, as I look at it, is you can customize it the way you want to, as long as you plan ahead. What do I mean by that? So there's really 3 ways somebody can get paid. If you're a buyer's agent, there's 3 ways you can pay your buyer's agent who's if you're a buyer, there's 3 ways you can pay your agent who's representing you. The traditional way you can't do anymore. The traditional way was the seller said, I'm paying the listing agent, let's say 5%, and the listing agent agrees to pay half of that, or 2.5%, to the buyer's agent, which creates confusion because contractually now, the buyer's agent is getting paid by the listing agent, they're getting paid by the seller, they're contractually limited. That has gone away. It's no longer allowed for a buyer's agent to be paid by the listing agency. So what are your options? There's three. One, the buyer can pay money directly to the buyer's agent. As you mentioned, though, if you're tight for down payment, that's an additional cost you didn't have before. So there's two other options you can use to that can work well. And this is where you need to meet with your agent and come up with a solution. One option is you can say, I'm going to pay you, Mr. Buyer's agent, but I want you to get the commission paid to you from the seller, not the selling agent, but the seller. That the seller agrees to pay kind of like a closing cost, the buyer's agent commission. They're not hiring the buyer's agent. They're not contractually with the buyer's agent, but they're agreeing that the cost the buyer would otherwise pay, they will pay on their behalf, just like they might pay for escrow fees, they might pay for a loan origination fee, they might pay for a home inspection fee, they agree to pay the buyer's commission. The second way that you can do it is that the buyer can say, I'll pay you, my buyer's agent, the fee, but I want you to negotiate from the seller a general concession equal to the commission, let's say 2.5%. And so while the seller is not specifically paying money to the commission, they're giving a concession to the buyer that the buyer can use any way they want as cash, and then use that towards the commissions. Now, it can all be in whole or in part, meaning as a buyer's agent, I might say, I want to get paid 3%. Mm-hmm. And if the seller only pays 2.5%, Mr. Buyer, either you agree to pay the difference, the half, or I agree to waive the half, and that all has to get handled in writing. So it sounds complicated, but those are the steps now that are required to be done in writing ahead of time. And whereas 99% of all deals before were all kind of done the same way, really every transaction really has to have a customized contract between the buyer and the buyer's agent, and then in turn discussed with the listing agent or the seller and negotiated and match up. Otherwise you have confusion. So again, it sounds confusing. It is confusing, though at the end of the day, this is all designed by lawyers. And again, with a professional real estate agent, you can end up with the solution that works best for you.
So I remember, again, going back to when I was much more involved in real estate, there was this idea of having a buyer's representation agreement, as opposed to a listing agreement was really a seller representation agreement back then. But these buyer's agreements were rarely used. So what do you anticipate about buyer's representation agreements? Are they going to become commonplace, do you think, or do they have to become commonplace? And if so, how is that all going to evolve?
Buyers and buyer's agents will have to have a written agreement on every single transaction before they even look at a property. By law, there's certain information that can only be transferred to a consumer by a licensee. What's the price? How many bedrooms? How many bathrooms? Even though it's in the advertisement, some of this information requires a license in order to convey to the buyer. What's the zoning? What can I do with the property? Can I add an ADU? All these are things that require a license. And so for a buyer to be protected as a result of this settlement, there has to be a clarity, at least, as to who their agent is. And the clarity is either it is, when you go look at the property, it either is the agent in the open house. Again, and keep in mind, there has to be an agent of the seller in the open house legally to hold it open. So since that's an agent, there's possible confusion. Are they representing just the seller, or are they also representing the buyer? Most commonly, agents in open houses are not the listing agent. They're part of the listing agency. They're there to meet buyers and to gather them up and represent them. So a buyer is inclined to think the agent is there giving them good representative information, but now that has to be clarified in writing. So to answer your question, every single buyer is going to have to sign an agreement before seeing any property, period, going forward. That agreement, now, two things. The agreement might be limited in scope. It may or may not deal with commissions and contract. And also there'll be open houses and listing agencies that don't comply by these regulations. That's a whole nother area. What do you do when somebody, will there be people who violate the law? Well, of course, there's people who, sell heroin and traffic in guns, right? So of course, there's people going to hold open houses and not require a license. Relatively speaking, they're low on the totem pole of criminals. It's not criminal; it's civil. It's not even civil. It's a potential lawsuit. So will there be agents who don't know the law and violate the law? Yeah, I've gotten offers, and I've seen some of these. I think on a couple of these where they have no idea what to write. So it's just a matter, I think, of being professional. And from a buyer's agent, you probably have to sign something before you see any property at all.
So on the, I remember again when it used to be that when you represented a buyer, if you typically did not have an exclusive agreement to represent that, and so you would have real estate buyers who, they could be working with, who knows, 2, 5, 20 agents, right?
Right.
So will this improve from a real estate agent standpoint, having to have a buyer's representation agreement? Will this help solve that problem of potentially doing a lot of work to help someone and then finding out that they've, bought a property with another buyer's agent? In other words, are these exclusive buyer agents typically, or what's happening in that regard?
Right. Well, the agreements offer various levels of exclusivity. So I would say it depends on what the buyer and the agent agree on. I think there'll be buyer's agents who make the decision they only want to work exclusively. And there'll be other buyer's agents who will say, like, I'm one, I don't care. If you don't want to work with me, don't. If I show you a property and after helping you, you decide you don't like working with me, I'd rather you work with somebody else through the transaction than be stuck with me for the 90 days of going through the transaction, because it just gets worse. If we don't communicate well, I don't want to tie you in because of a contract. And I learned that a long time ago. And that's why I never used buyer agreements, because I just felt like either you want me to represent you or you don't. And if you don't, no offense, that's probably a you problem, not a me problem. And I'm busy enough without it. But I do think for newer agents, they're trained to think that they want to get people signed to these contracts. And I just think it's a big mistake to think ever that the contract binds the customer to you. Yes, legally it does. But do you really want to run your business based on legal entanglements? Or do you want your business to be based on creating value? And I think this is the point I'd make to kind of wrap up that question, which is all of these complications, they sound complicated and unnecessary, and they may be. But really, the professional agent looks at this as the opportunity to sell their customer on the value they create. One of my primary jobs as an agent is to explain complicated things to my customer so that they get it. Not that they trust me, but that they understand it and can help both of us make the best informed decision for them. And so this is the opportunity up front to start the process. And I'd like to think that when I talk to people at the end of that, they go, wow, you're explaining in a way that nobody else could. That's why I want to work with you. Not because you signed me some stupid contract that's going to force you, because I'm not going to sue you in court for my commission. Who's going to do that? Like, how embarrassing to go to a judge. They don't like me. They wanted to ditch me, but I want them to pay me my commission. Legally, might be entitled to it, but who wants to live a life that way? But I think the opportunity always is, and the thing I train a lot of real estate agents every week, and I say to them, I'm really a ninja real estate agent. I'm the guy that if you walk through the streets, you want me as your security guard to protect you, keep the bad guys away from you. If you want something done, to get it done. And the contracts are my sword and my knives and my stars. And if you use them properly, you use them to protect your customer. And if you use them improperly, they get into trouble. And I don't want to use the forms just to protect me. That gets to be a very lonely and frustrating business.
So shifting gears a little bit, we're both here in California, but this, we could ask this 50 times. How is the Department of Real Estate here in California dealing with this change? Presumably they're weighing in somehow.
Not really. There's good news and bad news. I think we're very fortunate in California to have the California Association of Realtors. We're the only association. I'll give you one example as an expert in probate and trust. Out of 50 states, no other state even has a form that discloses to buyers or sellers the risks and unique possible scenarios of a probate transaction. Now, it's true California is more complicated, but other states do have court confirmation. Other states do have probates where somebody has to be appointed to have the authority. They don't put that. Air forms, which are used nationally for commercial. The default form says this is not a probate. Well, what do they use when there is a probate? Apparently nothing, because there's no addendum, or they go to an attorney to write some sort of customized form. So I would say that we were very lucky in California. The California Association of Realtors has been very proactive, has worked very hard, updated the forms. I think they've done a great job. I think they're as clear as anything I've seen, and I do work with agents across the country. Other states have really been much more, because their states aren't as regulated, haven't needed as much as we have in California. But again, I think because this thing is becoming a national court case and the Department of Justice is a national organization, I think these other states are going to have to do some catch up in this area. And this is an area that they're scrambling. Other states are scrambling. In some states, they don't even have a state association. The MLSs are putting out individual forms, or the companies are putting out individual forms. And I'll share with you a funny story. You know, you and I were working on a case, and the attorney, when I explained to the attorney the settlement, he quite properly said to me, well, we should put verbiage in that we're not paying the commission to the buyer's agent, meaning we didn't want a buyer's agent to later come back and say, hey, you owe me money for this transaction. We wanted to put up front, no, you need to work out with your buyer what you want to get paid. That's common in commercial. And so to protect my client, and the attorney recommended it, I thought it was great. I'll just put in the MLS, neither seller nor seller's agency agrees to pay any commission to buyer's agent or buyer. That violates the settlement. That would have cost me $2,500. I got notified by my broker. We actually put those listings up a few days before the 17th. And my broker reached out to me and said, hey, you can't put the clarifying words, the truth, that you don't want to pay that. You have to act as though it's negotiable. And then when they give you the offer, you'll clarify it on the back end. And so it just shows how confusing to answer your question again, I think California, our department is so backlogged that, and again, a case you and I worked on, a simple change of management for a brokerage license took, I think, 6 months when we filed it before they approved it. And the company, meanwhile, is operating with this temporary license. Either they're covered, they're not covered. You know, the attorney gave us some advice. We did what the attorney recommended, but that's really weird. 6 months to change one name of a license to another. That's how backlogged our regulators are in California. So no, we're not lucky at all. But I think the association has filled that void, and I think in our case has done a really, really good job.
So I want to expand this now, and get a little bit beyond just the real estate. So I think this is a larger issue, and if we look historically, you know, going back 100 or so years ago, when there weren't departments of real estate, you know, agents acted completely unregulated, and I think we would both agree that there was quite a bit of fraud and such that went on, and that was the impetus for the creation of departments of real estate and a lot of other agencies. Now it seems like, though, that in general, and I don't mean to drive this in a political direction, just it from a business standpoint, it seems like more often the agencies that are charged with regulating a profession are behind the professional organizations in terms of keeping up with changes that are coming either because of technology or because of I don't know, market forces, et cetera. So how do we deal with it seems to become an ever widening gap between what needs to be done in essence to be successful as a professional, but not, you know, find oneself in some kind of regulatory hot water?
Yeah, you know, I think that I'll never forget when I was a first real estate agent and we had a purchase agreement form. There's like 5 or 6 pages, and I was doing some business in Nevada where the purchase agreement was 1 page. I thought, wow, you know, it's a whole different world. You know, I will say that, and again, the association forms are our industry's attempt to protect us and protect our customers. And so the fact that the forms created by the association are so long, I think are just that they're giving us a very extensive set of tools. And I believe they do them in a way that's very efficient. As an agent, they're just constantly improving them and making it easier for me to complete the form in a way that protects my customer. I think the regulatory bodies, it's like everything else. They always default towards more power. Whether or not the more power is good or bad, you can debate. If you think the government needs more control in real estate and housing, then okay. But I would say to you, the same people that we're trying to say should solve our housing problem take 6 months to change the license of a corporation from one approved broker to another. And I just think in California, our governmental regulation system is completely broken. It's just in every aspect of what they do, they are ineffective as a based on results. Just looking at what are they trying to do? We've built less housing and not more housing with a population going up. The results are they're not capable of handling it. At the same time, we have more regulations in an ever toughening environment. And, I don't know where it ends or does it end. And of course, that gets into some politics. But I would certainly say that's the challenge. And as a professional, and that's true in all our businesses, as a professional, our job is to learn about those regulations and find the way to steer ourselves and our clients clear of that. On one hand, I say myself and to others, I don't really care one way or the other. I'll beat my competitors and I'll do real well and I'll help my customers. On the other hand, I look around me and I see a lot of people struggling and suffering. And as a Californian in particular, I feel really bad over what I see as the decline of the state that I've grown up in. So I don't know where it ends, but it certainly seems to me that at some point people need to realize that the people who promise to solve problems by regulating them at the state level, that's not the solution. That's always been the opposite of the case, I think.
So last question, because unfortunately we need to wrap this up. But so you mentioned that for small offices, regional offices, they're not necessarily a part of this national settlement. So let's take what used to be very, very common here in California, I think across the country, a real estate agent, he works for a few years for somebody else. He gets his broker's license. He starts his own firm. He's a one-office shop, and he's doing well. He likes the freedom, and he doesn't want to have to be part of a large company. On the other hand, he also doesn't have the resources to fight a national lawsuit. So what advice do you have for that, single office operator, or maybe that operator who's got, 2 or 3 offices, in one area of whether it's California or Florida or, Ohio?
So I think one of the challenges of regulation is it forces a consolidation in the industry. You look at any business and where you have intense regulation, automobiles, you have a few companies, whereas, if you follow history, in the 1920s, 30s, and 40s, we had hundreds of companies manufacturing automobiles. And as regulation got stronger, it consolidated down to the players we have now. And I think that's happening in real estate as well, not just with real estate agencies, but kind of hybrids or offshoots like Zillow and Redfin are bigger and bigger, pay no federal taxes because they're venture capital funded, and yet destroy the real estate agency business. So to answer your question, what does the individual do? My solution was to affiliate with a large national company, eXp Realty. I'm a broker associate. I run my own business. I delegate to them certain regulations and certain administrative tasks. And as a result, for a very small fee, I operate my business the way I want to within the umbrella of their organization. And that gives me a lot of coverage, a lot of resources and support. I'm sure there are other companies in addition to XP that people might explore. I've been with them 5.5 years. It's worked for me. I couldn't imagine being independent today for that reason, that the regulations and the things move so quickly that I need to have access to forms and guidance. I go into our broker room once a week to talk to my colleagues there to get updates and strategies on how to handle things. The case you and I are involved with, where there's multiple properties, is it a vacant lot or is it a commercial lot? Who really knows? But we have to make a decision. So these are things that I think are, and I have errors and omissions insurance. I've never been sued. So it's not like I'm running away from the law, but I think to give the best service and to do it with, a clear heart, clear conscience, the answer I've come up with is, it's hard to be independent. I don't see the advantage anymore of that. I was at one time, and that's why I affiliated with a larger company to maybe give me some coverage on these important regulatory issues.
Well, on that, I mean, I don't mean this as a criticism of you, but it's almost, it almost sounds, a little bit un-American, right? Because we think of America as being the place where the individual has opportunity, and unfortunately, it may be that the real estate business is following so many others, the medical business and such, where conglomeration is just the necessity for survival, unfortunately. So
Seems like that's a very good example. I think, you and I know you've had some recent involvement with the medical industry. If you haven't, it's not like it was 10 years ago. It's a whole different industry, and I don't think it's good for the consumer. Is it good for the doctor? Not, I don't know, but I don't think it's good for the consumer. That just to get an appointment with a doctor now is so challenging.
yeah, I mean, based on what's happened with me and talking to my doctors, I don't think they particularly like it either.
Mm-mm.
But in order to survive, this is what they have to do. So
Yeah.
yeah, this is part of a larger discussion of sort. So well, hopefully we'll have you back maybe in about 3 to 6 months, something like that, as this whole situation develops, and we can bring more clarity to it, because I think that we're only at the beginning, and who knows how in the end this is all going to shake out. You did mention that there are some companies that are still fighting. Presumably, if somehow they prevail, then maybe we'll see another tectonic shift. So that's possible as well.
Well, I think if the court decision, is entered, then they're going to be held liable to what the judge decides. It's only those who agree to the settlement they'll avoid it. So, I guess you could try to outrun that for a period of time. But at some point, there are attorneys who are in the business of tracking you down and forcing you to pay the fees. So, I wish them good luck. I'm not saying I want to see them caught, but I wish them good luck.
Yeah. Well, Bill, thanks so much for coming on the show today. I really appreciate it. And for all of you who are watching, thank you for joining us. If you have any questions, Bill, I'll put your contact information in the show notes, and you can contact Bill, and he'll be happy to answer your questions, and not just about real estate agency, about real estate in general. I know I was talking to a friend of mine yesterday that I had referred to Bill, and he was telling me that he had set up a meeting, and because of a family emergency had to cancel it, but he's got to reschedule it because it's important for him to get the advice of a qualified professional before he makes a decision. And in his case, it's a pretty complex decision that he needs to make. So Bill can't say this because he's my guest, but I can say it shamelessly. If you have questions about real estate, do get in touch with Bill. We've known each other now for, over 3 decades, right? I think it is, which is pretty amazing since we're both only 25.
I'm a little older. 25.
So am I.
True disclosure.
Yeah. Okay. So before I sign off, just real quickly, tomorrow at 10 a.m. Pacific time is my show, Business Lessons from the Military. And I'm going to be talking about shrewd risk-taking, looking at MacArthur's success at the Battle of Inchon. Mm-hmm. And then on Wednesday at 10 a.m. is my show, People Making Money. And I'm going to be talking about the spiritual dimension of business. I don't think I've ever addressed this topic before, but I think faith plays a profound role in our professional lives. And so this is a subject that I want to explore with you. And then on Thursday is my every other week show, Jiggers' Place, at 5 p.m. Pacific time. And our topic is treating people kind or nice. And it seems like lately I have that discussion with people 2-3 times a week. And I had this discussion with my nephew last night. He was very disturbed by what he sees going on. So I invite you to join me again, 5 p.m. Thursday Pacific time for a cocktail. and a discussion about all those things that make life worth living besides our professional and business lives. So again, Bill, thanks so much for joining me. I'll have you hang on just for a moment after we go offline. And for all of you out there watching, again, thank you. Wishing you a wonderful rest of the day. And signing off as I always do, Marie, darling, you are my belle. You really are. Courage at all times, my friends.